A very good morning and a warm welcome to everybody joining us online today. We have folks dialing in from right across Queensland, and I really want to acknowledge you all for being here. My name's Monica Taylor. I'm your facilitator for this morning's Human Rights in Action webinar on coercive control. I'm joined by three incredible women panelists who I'm going to introduce you to momentarily. But first, before we do that though, the panelists and I really just wanted to take 30 seconds to sit in silence and remember anybody impacted by the topic of our conversation today, domestic and family violence. Thank you, everybody. From Brisbane, where I sit today, I acknowledge the traditional owners of the land on which this webinar is being facilitated, the Turrbal and Yagara peoples. I want to pay my respects to all elders past and present and to emerging leaders. And I especially welcome all First Nations people joining us for today's discussion, whether you're in the audience or here as a panelist. If you are on the line and you feel inclined, please let us know where you're dialing in from today, which traditional lands. We are meeting, of course, on sovereign land that was never ceded. I'm so pleased to introduce our panelists for you now. Our first speaker is going to be Zoe Rathis. Zoe has been an academic at Griffith University Law School since 2005. Her research focuses on domestic and family violence, particularly in family law. Prior to entering the University Academy, though, Zoe was the coordinator of the Women's Legal Service in Brisbane for 15 years. She also has worked in private practice, and she spent time in South Africa in the mid-1990s. And I could see that's why she was bopping along to Maria Makeba, the song at the beginning. In South Africa, she was working on projects around gender and the law. In 2011, in recognition of her service to law, particularly through contributions to the rights of women, children, and the Indigenous community, to education and professional organisations, Zoe was appointed a member of the Order of Australia. She currently serves as the chair of the Immigrant Women's Support Service, and she's on the Queensland Law Society's Domestic Violence Committee. I'm going to throw to Zoe first, but before I do, I'd like to introduce the rest of our speakers. Seblewok Tadesse is a community leader, a cultural specialist, and a social justice advocate. Seble's country of origin is Ethiopia. She was resettled in Australia in 2009, and she became an Australian citizen in 2016. Seble is an experienced refugee settlement case manager, and she's director of the South's Community Hub. She's a leading force in striving for system change and culturally sensitive, holistic support for women, men, and children from culturally diverse backgrounds who've experienced domestic and family violence. This work that Seble does includes developing a men managing change program to address the root causes of domestic and family violence and to support peace building within families. Seble recognises the multiple identities that lie at the heart of working and speaking on behalf of the called community. And our third speaker is Samantha Cooper. Samantha is a proud Gumbaynggirr woman from the mid-north coast of New South Wales, and she works at Community Legal Centres Queensland as a sector sustainability coordinator. Sam previously worked at Legal Aid Queensland as the Aboriginal Policy Project Officer, implementing the First Nations Strategic Plan for reducing the overrepresentation of Aboriginal and Torres Strait Islander people in the criminal justice system. She was the Indigenous Domestic Violence Specialist in Moreton Bay, and she ran the pilot project for the high-risk team who implemented the integrated service response. Sam has received numerous awards, including for her activism and her work to empower practitioners, individuals, and organisations working in domestic and family violence or in the context of frontline trauma. So the way in which we're going to roll today, folks, is each speaker will have 10 minutes, and then we're going to move into a Q&A style discussion with the time that we have available. And we do encourage your questions and your comments in the chat function. The aim of today's event is really to do three things. We want to explain the current inquiry, the task force, and the timeframes that are at play. Through a human rights lens, we want to really critically discuss what coercive control really means in practice and ask ourselves the question whether creating new offences is the answer to the problem of domestic and family violence, in particular for Indigenous and multicultural called communities. And then finally, we really want to encourage you as audience members to make a submission to the task force. Submissions for the first discussion paper are due on Friday, the 9th of July. So that's 8 working days from today, folks. So just keep in mind that those timeframes are there. A second discussion paper was recently released with a slightly longer timeframe, but we'll get into the guts of the first one today. Just finally, the discussion may bring up some emotions for people, and if that is the case, just do what you need to do. You can drop out of the session if that's what's necessary. The session is being recorded. The slides are going to be made available to people after the event. So please just take care of yourself. Okay, so I will now mute myself and hand over to you, Zoe, for our introduction. Thank you so much.
Hi everyone, thanks Monica very much, and thank you for inviting me to be a part of this panel today. Of course what I'm now trying to do. Oh, I am screen sharing already apparently. Okay, so from beginning, there we go. Okay, so I will also acknowledge the traditional owners of the land where we are gathered, and thank you very much for asking me to be a part of this today. I have a job to be finished in 10 minutes. I'm very bad at that, but I know that other fantastic people are waiting to speak, so I'm going to do my absolute best. The job that I've set myself for today is to try to take an opportunity to explain to you in the audience what this task force is really about. I'm sure that a lot of you have already been thinking about the issue of coercive control, perhaps for many years, long before it became an expression that was on the tip of everyone's tongue. So I'm trying to put together what this task force is actually about so that you can think about how you might contribute to it. So it is called the Women's Safety and Justice Task Force. The cover of it is there on my screen, and it was established only in March this year and already is accepting submissions which are due by the end of next week, and we'll be moving forward. So very quick work. And of course, there's always politics at play with these things. Coercive control has become a massive issue under discussion, and the Queensland government presumably felt that something needed to be done. Some statement needs to be made at government level about this. They've appointed Margaret McMurdo, who of course many of you would be familiar with, former President of the Court of Appeal, and someone who has worked incredibly hard throughout her life dealing with issues relevant to women, and has I guess a history of being a defence lawyer many, many years ago, and has done a lot of work with women. So someone who can maybe see all sides of the story, very useful to have as a chair. And the discussion paper that we're talking about today, responses due by the 9th of July. I'm not going to spend time on this. I've just put that list there for your assistance. You can go onto the task force website and see all of that. But just to give you that idea that you can see, there's police, there's barristers, solicitors, there's people with a range of experience in the Aboriginal and Torres Strait Islander community, in the cold community, there's academics. So it's a very broad committee. The paper itself, I really want to commend those who wrote it in terms of the various issues that I had been thinking about and speaking to many people about before the paper actually came out. There's almost nothing that I've heard people talking about that they haven't dealt with in the paper. And it's dealt with in a way, I think, that really leaves the community to make their own decisions then. So ideas are put forward, the issues that people need to think about are described in some detail, and then it's up to you to decide what you think about that information. So, but it is quite complicated. There are 72 questions throughout the paper. There is a consolidated list that Monica kindly pointed out to me when I thought there wasn't a consolidated list. There is. But there's 72 questions. There's then at the end 13 options for legislating. And in respect of each of those options, you can answer 8 different questions. So I haven't done the total maths. I don't want to. Just as some law reform tips though, look, I always think it's very useful to answer the questions as presented. The people who have to bring all this information together, if everyone has answered them as per the questions asked, that is the easiest way for things obviously to be brought together. Do not feel that you need to answer every question. You don't. Pick out those questions that are within your expertise, that are within your working life or within your personal experience, and go for those. No one, well, I don't know. I can't imagine many people are actually going to answer all 72 questions. Most people don't have that level of expertise across so many areas. And I'm sure, as many of you are aware, client stories will be quite critical, really, and personal stories, obviously, for those who have experienced this. But the personal narrative is always something that brings that extra energy to a law reform submission and stops it from being the kind of academic tome that I will end up putting together, because that's my job. So, look, there are a lot of very general questions asked, and I encourage you to look and understand those questions. So, questions about what do you think is meant by coercive control? Questions about how could community education be done better? There are a lot of questions about how the current domestic violence legislation works, particularly aimed at frontline service providers. So, what have you seen work and what have you seen not work? You don't need to think about legal expertise. They're not looking for legal expertise for people to answer that. They want people to say what really happens when working with the domestic violence legislation. How is safety for victims improved or not? What are the police responses? How does the court work with the DV Act? There's questions about bail, questions about sentencing laws, and they come up quite a few different times in different areas. So for those of you who want to comment about bail or about sentencing, there are many places that you can go to do that throughout the paper. And then questions about service provision, particularly looking at rural and regional service provision, culturally appropriate provision, talking about First Peoples and cold people, and then is some discussion about LGBTIQ+. I can't say that any of those matters are dealt with in significant detail, but nor could you expect a government to cover off on everything in their discussion paper. Almost everything is identified somewhere, so it provides a trigger for you to talk about what you most want to. And I think that that's the benefit of this. And there's a lot of discussion about training and different ways of doing training. So, as I have called this, the more technical bits of the paper, I think that there's a very useful summary of the laws that already exist in Australia and around the world. So the only state in Australia that's actually legislated anything yet is Tasmania. There's a very neat little discussion about that. I've put down the bottom of my slide where you'll find that. For those of you who are not aware of how that's going, have a look at that. There's also a quick summary of what's happening in England and Wales and Ireland, which I don't have time to talk about. I thought I would just mention also a quick discussion about Scotland, which seems to some extent to be being described around the world as the gold standard. It kind of came along after the England, Wales and Ireland had already legislated. They've tried to learn from that. It's a standalone offence. There's a nice little description of how it goes contained in the discussion paper. And what you're invited to do is to have a look at those models which exist in other places and think about what might be the benefits and risks of each of those models. And do you think that some of those elements might work here in Queensland? Always remembering that translating legal ideas from one place to another place can be complicated. Okay, so what do they really say about legislating against coercive control? And whatever else, you need to understand that what they're saying, and of course this is correct, but legislate does not mean criminalise. So criminalising is one option, but it is not the only option, and it is not a natural progression. Legislate does not mean criminalise. They've also made very clear in the discussion paper that the best way to deal with coercive control might be to introduce no new legislation and only improve how the existing law works. So I think that all that is extremely interesting, and you need to understand that you really have been invited to submit anything from do nothing to do many different things, including criminalising and creating an offence that somehow relates to coercive control. They set out in great detail, and I thought very effectively in the discussion paper, the possible risks and benefits of legislating in relation to coercive control. I'm sure that many of you have thought about these things, and some of them are quite obvious. And there is certainly a reasonably well thought view, it seems to me, from places that have done this, that whatever else, introducing a specific piece of legislation about coercive control changes the conversation. But the question is, are there too many risks? Is that the way that we change the conversation, or could we change it in some other ways? There are significant risks of net widening, over-criminalisation, misidentification of who the real victim is, and some real issues, I think, for Aboriginal and Torres Strait Islander women, and increasing their overrepresentation in the criminal justice system. Monica, I don't know if you can talk to me on whether I should be keeping quiet at the moment, or whether I can do the last couple of slides, or whether I should leave that. But I don't know if you can do that.
You've done very good, Zoe. I think you can maybe just make quick reference to those final slides.
Okay, I'll show people what they are. So, look, I just thought I'd end with a couple of areas that I'm particularly concerned about, that this paper offers a chance to talk about, which may not be the ones that most of you are thinking about. I'm sure you already have well-formed views about a lot of the issues raised in this paper, but I do really say read it carefully and think about how you want to express those views. But a couple of things that some of you might not have thought about, I'm going to cover off on here. What do I think about a standalone offence of coercive control? The answer is I haven't decided yet. But I'm swinging towards no, because I am concerned about the risks. I can see that there's a sense that doing something now is a very important message to give to the community, but I have my concerns. I certainly do not think it's useful to put it in with the offence of stalking. I think that's incredibly confusing. I like the idea of it being seen as a course of conduct offence, and please have a look at what they say about that. There are also possibilities of coming up with a more general notion of an offence of domestic violence, or an offence called cruelty, that would incorporate aspects of coercive control. So think about that. But there are some difficulties in having an offence called domestic violence, because it seems to me then that every time anyone effectively takes out a protection order, the possibility of there also being the offence of domestic violence exists. And we might just over-criminalise everyone that way. So there we go. They talk about a definition. When should there be? Should we now make sure that every definition of domestic violence assumes or encompasses within it the context of coercive control? This is a question that they ask at question 69. Please, I say no to that. And the reason that I say no to that is because this is what we've seen in family law. Once you say that any for something to be domestic violence, it must be in the context of coercive control. It means that every woman who's trying to claim that they've been a victim of domestic violence has to be able to prove a context of coercive control, which is actually a very nebulous and difficult thing to prove in a court of law. And we see in family law judges asking questions like, was this coercively controlling or not? And if not, maybe it was just situational or separation triggered or something like this. Therefore, it's not domestic violence. I see that as being quite dangerous, and there's no discussion of that in the discussion paper. The final issue is a really complicated one, but there's actually an opportunity in this paper to once again think about how we create defences for women who end up being charged with offences of violence when they have retaliated against or attacked an abusive partner. It's all in there. I've put the references there. I'm not going to try and explain it now, but for those of you interested in that issue, there's another chance to talk about this here. These evidential rules are part and parcel of that issue. I'm sure I've spelt a word wrongly there. It's over to you. Finished.
Just unmuting myself and just saying thank you so much, Zoe. That was a terrific overview. I'm going to hand straight over now to Samantha Cooper. Sam, the floor is yours.
Okay, thank you. My apologies, I don't know whether or not you can see me or the screen or what's happening here. And I am unable to start my video at the moment, but I will continue on anyway and we can get that sorted. Before I begin, I would also like to acknowledge the traditional owners of the lands in which I'm speaking from today, the Turrbal and the Yagara people. I pay my respects and I thank them very much for taking care of the lands that we get to live, work and play on. And I would also like to welcome any First Nations people listening in today. I would like to acknowledge and put up front immediately that although overrepresented in domestic and family violence space and in the criminal justice space, violence is not a part of Aboriginal and Torres Strait Islander culture. And I think it's really important that we keep that in mind as we start to have these discussions. And I would also like to take a moment, thank you for doing that in the beginning, Monica, to pay my respects to the families of those who have lost people to domestic and family violence. Thirdly, I would also like to point out that while I am speaking as an Aboriginal woman, I'm a very proud Gumbaynggirr woman. I grew up in the north coast of New South Wales, and I won't hold it against you that New South Wales has won the last 2 Origin games. But I would also like to point out that I don't speak on behalf of anybody else. I don't speak on behalf of anybody outside of myself. And I am, of course, very well informed. My opinions are very well informed by incredible, powerful aunties, but I do not speak on behalf of them or of any other group. And it's my cultural obligation, my cultural responsibility to point that out as well. In my discussion today, I understand that we've only got 10 minutes, and it is very difficult to capture everything inside that 10 minutes. I do have a bit of experience. I'm a survivor advocate. I have been a very high-risk project worker in Moreton Bay, and I now work for Community Legal Centres Queensland, and that is not part of my role, but I do also run a consultancy with my sister, where we do a lot of work with organisations on how to work with First Nations women, particularly in the domestic family violence space. Today, I would like to firstly talk about a few different things, and please stay with me. There's a lot to cram into about 10 minutes, but one of the papers that I would really like to, one of the things that I would really like to point out, first of all, is that there's a paper by Debbie Gilroy and Professor Chelsea Portigo articulating the racial power structures which are in place when we start to have these kinds of conversations. That article is in no uncertain terms. That's the title of it, and it's regarding the violence of criminalising coercive control. It's a joint statement by Sisters Inside and the Institute for Collaborative Race Research on the 17th of May. It's on the Sisters Inside website, and I would really highly recommend giving it a read. And I would also like to just acknowledge Selma Schwartz, who's the PLO at Quibbles, and is on the task force, and I acknowledge her and her work, and I pay my respect to her in this role, in this space in particular. But throughout the article that I was just referring to, they have very rightly pointed out 6 pretty critical issues that I will just draw your attention to. The first is that the task force terms of reference are very restrictive, they're severely restrictive. And I will at the outset say that I'm not for or against coercive control. I think that it needs to play out, and I agree with that. But I do also have some very serious concerns about the terms of reference which we start this conversation. And they presuppose a carceral solution as the only and best response to coercive control. And of course, Aboriginal and Torres Strait Islander people are already so severely overrepresented in the criminal justice system, and we have laws in place which are already not being utilised, and legislation which is already not being utilised and not being used to its full extent. And with Aboriginal women already 30% of, roughly 30% of the prison system, I'm also on the board of Prisons Legal Service, so I was kind of take a joint role approach to this conversation. I just don't think that creating a carceral solution for such a complex social issue can possibly be included in terms of reference. I just don't see how that works. It seems as though it's from the outset already quite tainted. The terms of reference ignore the existing evidence base. So the statistical, the theoretical, and the testimonial relating to the violent relationship Indigenous women have with the criminal legal system. The task force terms of reference are explicitly discriminatory. They name Aboriginal and Torres Strait Islander women as the only racialised category of women considered as both victims and offenders. In their scope, the terms of reference fail to adhere to their own guiding principles. Most notably, they fail to protect and promote human rights, as in this conversation, or to employ a trauma-informed and evidence-based approach. The terms of reference fail to provide a definition of coercive control or any conceptual clarity in related to this very highly contested term, particularly at the moment. It's certainly a risk that we start to politicize some of these issues rather than recognising that these issues are very real for a lot of women and children around Queensland and in fact around the world. And for all these reasons, the terms of reference are an enabler to the state's exercising of coercive control over Aboriginal and Torres Strait Islander women who are very classically portrayed as poor victims and very commonly misidentified as perpetrators at a first response, and then as the case starts to unfold. And I've worked with lots of Aboriginal women who are fleeing domestic and family violence with children, and I just see this play out time and time again, not only as they experience coercive control in different ways, the way that they are a bit misbelieved by the people who are put in place to protect them. The primary issue with the terms of reference is that they actually ask in the question, can we look at the best way to legislate against coercive control, and not whether or not we should? And I think whilst it might play out in the 72 questions or whatever it is that Zoe pointed out, that may not necessarily be the right option. At the outset, they're saying this is going to happen, and I think there are huge problems with beginning a conversation with that kind of question being posed, and the vagueness of the nature of coercive control and the difficulty demonstrating it and documenting it, of course, makes coercive control legislation an incredibly powerful weapon in the criminalisation of Indigenous women. And a lot of this wording comes directly from Chelsea Portigo and from Debbie Kilroy. So I will again just acknowledge their incredible work in this space and their importance of their voice. I think from my personal experience, I have worked with lots of women who fall at the hands of coercive control daily and really struggle to recognise it, and who are consistently throwing themselves at the criminal justice system as a response, or trying to get a response out of them in order to protect them, and they are consistently failed. As I said before, they make up about 30% of Aboriginal and Torres Strait Islander women, make up about 30% of the prison population. They are overrepresented in the sentence population, not just in those who are awaiting a sentencing. And since 2013, there's been a 49% increase of Aboriginal and Torres Strait Islander women who have been sentenced, compared to 6% among non-Indigenous women. So they're already the fastest growing prison population, misrepresented and misidentified as perpetrators. And the systems, although of course they need to be accessible, for anybody who needs protection are very easily manipulated by perpetrators, which again is what we're starting to see come through with some of the primary complaints in the use of systems abuse and that kind of thing against particularly Aboriginal and Torres Strait Islander women. I think it is again alarming that, you know, I can sit here as an Aboriginal woman, as an advocate, and I can tell you, hundreds of war stories about women that I've worked with in these really unfortunate and dangerous situations. And then I would hope to look to a terms of reference discussing such a critical issue and not see that Aboriginal and Torres Strait Islander women are the only women named as offenders in this kind of inquiry. And I just can't understand why that would be your starting, your jumping off point. I don't know if anybody has seen the See What You Made Me Do series. It's made headlines across the country, and it highlighted not so much the need for criminalisation of coercive control for First Nations women, but the ways in which Indigenous women are often misidentified as perpetrators. I just want to make sure that I get the pronunciation of this family right. So the story of Tamika Malali was about the dangerous intersection that race plays with domestic and family violence, and her little one, Charlie, was murdered by her abusive partner as she was trying to leave. He took the child, and it was an absolutely horrific story where this grandfather is on the phone and pleading with police to please try and find the grandson. He's absolutely dismissed and then eventually charged. She's taken away on site, covered in a sheet covered in blood and misidentified as a perpetrator. She's laying in the middle of the street. Her neighbours saying, look, this has happened. She's a victim, but because she wasn't a good victim, because she doesn't want to talk to police, because she just wanted to know where her baby was, she's misidentified. And after being really severely beaten, she's then taken into custody. Her little one is taken by her ex-partner and eventually killed. And I think that is a tragic story of what plays out time and time again for First Nations families, particularly for First Nations women who are not good victims. They don't want to talk to police. They are very highly emotive, particularly if they've been under the scourge of coercive control for however long. I mean, days is long enough, let alone weeks, months, and years. And so by the time it all plays out and there's finally a response from police and they're erratic or upset or unable to articulate how much danger they're really in, they're misidentified. And I just can't stress enough the dangers of First Nations women and being abused by potentially the criminalisation of something like coercive control, particularly as victims who start to use mechanisms such as social media to try and find out where a partner is, not necessarily to stalk them or to cause any harm or grief. It is just to keep themselves safe. That safety mechanism is something that we've been trying to work with women for a long time, in particular as DV has started to become more and more sophisticated, and the ways in which perpetrators are starting to use systems against people, starting to use stalking behaviours against people, and the ways in which women are then trying to keep themselves safe can, if we are to criminalise it, be then used against them. And I can't imagine that would be the best outcome if that's what we're looking at doing. The experience of victims as Aboriginal women, my experience as an advocate and a project support worker, are consistently disbelieved. I took one grandmother to police 4 times before the perpetrator turned up at her house. It started with a birthday card. It started with a friend request by a fake account on Facebook. It started with a call asking to collect the child, and then all of a sudden he's out the front of her house with a shotgun threatening to kill her unless she hands over the child. So again, I talk about this from a very grassroots level, just to say, if we are to start having this conversation, we need to start having this conversation at a grassroots level and perhaps start to really look at the ways in which we can protect victims in this space and prevent them from being misidentified in this coercive control conversation. And I don't think that there's anything wrong with looking at legislation down the track as a potential option, but certainly right now I can't see that we would jump from a grassroots option to straight to legislation. And there's a real risk here that the people who we are then going to ask to sit on a jury of our peers also don't understand coercive control as effectively and sophisticatedly as we would need to find a proper guilty verdict. So there's lots that we could say, but stop.
Sam, thank you so much. Thank you. Those stories, I think, give such context to the violence as perpetrated by the state against Aboriginal and Torres Strait Islander women. And those are the stories that we need to hear. So thank you very much. Now, and just checking in with our audience, remember to do what you need to do if the stories do get a little heavy. We're going to move now to Seblewok. Seble is going to give us a different context, working in called communities. So the sort of issues that she sees also from a very grassroots level. So thank you very much, Seble.
Thank you, Monique. I think you can hear me now. Okay. I just want to thank you for previous speakers and really good setting and try to understand how complex it is and for different community, but in general, coercive control is something we can't just only address it in one kind of context, but in multiple. But before I say that, I want to acknowledge the Indigenous people where I am now in Sunshine Coast. I think if I pronounce it properly, I'm in the land of Gabi and Jinbara land. There is a wealth of Aboriginal in this land, so I respect the past and the present leaders, and for me and many of us who came from different cultural group being welcome and given this land, this beautiful land. So I appreciate, I acknowledge the Indigenous people. And just saying that, I want to give a bit just a brief overview of our work. And South Community Hub was been working on the domestic family violence prevention space, early primary prevention space, the last 4 years. So our work start on just first try to understand what is a real deep down cause for the culturally, linguistically diverse community group, mainly new emerging community group, migrant and refugee humanitarian entrants. Our work was been starting by community conversation, really from what is actually domestic family violence, how actually that being perceived. And also with the hope of try to extract some cultural strengths, because in each culture has its own cultural strengths to addressing this domestic family violence in many ways. So with our work, we cover, we involve 167 people from in Southeast, Middle East, and also the African background. And from that, we just 84 of them men and 83 female participants. So our project was mainly try to, as I said, there is to the definition, how it's been defined for a culturally newly emerging community group. One of the things we really striking us is that 56% of our participants was saying, confirmed that the new and emerging community group don't understand what constitute in domestic family violence, and 21% indicate that majority of them do not understand. 30% of participants do understand, with others do not, or their awareness is limited. 8% mentioned that some of them are not fully aware or understanding what consists in the domestic family violence law. So what we really learned in that, just some of them really mixing up what is domestic family violence, let alone different type of violence. But there is a few section of the respondent also saying, yes, they do understand, but they really struggling to understand with the cultural here, especially those who came in this when there's forming of acculturation. There is two cultures where what is actually a gender norm and what is acceptable, what's not acceptable, what's legal, what's illegal things, because some culture or countries, they don't have any defined kind of meaning for domestic family violence itself, but there is a certain form within that culture, keeping the community, keeping the family together. And most of the case actually men non necessarily themselves want to have that, but because there is expectation of manhood, masculinity, so that is actually being them. So if I say, for example, from our finding, there is a three from the gender point of view, there's three understanding, especially from men point of view. Men who, well, by culture, tradition, or being absence of knowledge, they have this, their masculinity is, it must to be that kind of like, for example, controlling the wife, telling what to do, being in charge of finance, or other form of like what we call considered coercive control, being actually expected from them to do that. And when they come in here, that there is a clash happening. There is a culture, as I call it earlier, acculturation, when this culture, yes, this kind of like, for example, beating your wife, or this is it's not actually, it's legal. It's not legal. It is illegal. And then there is a kind of a conflict to start. And then they displaced of their gender or manhood. And there is another man who sometimes just being really aware, but at the same time don't know how to actually stop and change that behavior. And even if they are aware, they don't know how to change them, because our findings with a partner with QT, we try to find how many actually culturally called main behavioral change programs. It's surprising. There's nothing pretty much, especially for new emerging community group. There's nothing. They're just adapting but main existing behavioral program, which sometimes really not actually connect with the culture of people. So because of that, they don't know how to do it, and they're even willing to change and continue having their family together and want to be in their, their wife and with their children. There is other third of the men who are from this community group, who are actually really choose. They do have understanding about what it means domestic family violence. They do understand what the consequences, and then they actually choose that behavior and harming the women. And again, saying this because we're talking about the coercive control. For me, as a culture group, I'm more of seeing, I was been looking at the data in Australia. 1 in 4 women actually experiencing the coercive control, and 1 in 6 is domestic family violence in general. But the thing is, when it comes to in the cultural group, which we have, many of the women who participate, 83 of them, telling us actually, yes, there is kind of, the beating or the physical violence. They can get sometimes support. Sometimes when they call the police, 43% of them say yes, police support them. But the other remaining is they said actually police aggravating the matter because they don't understanding the precondition of that situation. And often the women, as I said, very sometimes this cultural group are, I'm talking about different cultural background. For example, some community group only have their own identity group, maybe not more than 1,000 people or 2,000 in Brisbane or Queensland in general. In that small community, sometimes it's very, very hard, just for women to come out and even charge, because there is another expectation from her cultural, her other community social responsibility, which she needs to kind of keep the culture together, or another form, the challenge she has is kind of she's suffering that. So because of that, often they try to hiding it, or they try to solving within the cultural group. But the thing is, from those who are seeking a support, getting out of that relation, so especially those the third group perpetuator who deliberately using, they knew it's physical violence is actually a problem, they will be in trouble. So they choose actually the coercive control, using the legal system, using even the other cultural expectation for women to do, using that smallness, and they actually making women more than harming the body, the mental harmness, like mental health. From my experience, even later this year only, I have 6 women who been, yes, they managed to get out of that relation. They break up, like you said, okay, I don't want anymore this relationship. I have to protect myself and the children. But the problem, they couldn't, the law or the legal system, which we have now, doesn't actually support them in terms of the harm of this, which relate in coercive control. Because in the beginning, before they separate that relation, they were being harmed mentally, and some of them even developing a paranoid, that part goes up to psychotic, and sometimes using that, making women in that kind of health issue so that they take the children. Many of the women in the cultural group, children means everything. I'm sure in any other culture, so women often being vulnerable when it comes to their children. So using that family law where now not much even protecting the women. So even though financially women have to be independent, so that's try to avoid a relationship with that, and they use so many other coercive control violence towards the women, and then that actually leading their mental illness later on, even after they left the relationship. So from my point, yes, from the community point of view, yeah, they always are preferring from the respondent. We ask, well, how can we address this issue of domestic family violence in general? What we have is many of the women and men and general community just saying they need more education about legal education, even to understand the domestic family violence law, but also come out with a more work invest on the prevention side of it, especially for those two type of perpetrator, which some because of cultural expectation, the acculturation issue, and the other one also they want to change, but there is no change in behavioral programs. For this, we need to invest a lot of resource and education so that women also seek support and men themselves also get support. But what my point in here, from our work, those the third ones, which they choose to deliberately to damage the other person mental well-beingness, because I call it mental health also, it's one form of health matter. As a body, when you've been someone hitting your body, there is a law, it's a crime. You can't, you can't harm another person. But we are talking about the women who've been harmed mentally. Some of them forever, they can't even function without medication because they can't be getting their past life back because their mental well-being has been damaged. So for these women, what I see this law will be, especially the coercive control, make it as a standalone criminal legalization, that actually will help those who really are a victim of it. As I said, I'm excluding those who possibly want to change and the perpetrator who do that because they don't know how to change themselves. It need to be investment. It need to be a protection for them, not to be by this law to be profiling. So again, from our cultural point of view, I really share also some point of view. There is a fear our men can be profiled because which we can't. We don't want to see that. But because we don't want to see that, it doesn't mean we have to leave it this the vulnerable who are losing their life because of the person who choose the violence to harm the other person. So they have a right to be protected. So for me, I think it's important to look at it, excluding the kind of, yes, there is if we're criminalizing this as standalone, we need to have investment from the government, from the state to protect those who are not falling in the real, who choose to be abusing others. Maybe I'll talk more. Thanks.
Yeah. That's so fantastic. Thank you very much, Seble. And to the other panelists, please switch on your videos because with the time that we have remaining, I'll ask a few questions. Seble, your final, I thought what you did so beautifully there was really effectively, a human rights analysis, the benefits outweighing the risks in terms of yes, of course, there is more education needed. That's one of the benefits potentially that can happen with a new law, that educative function, although, certainly there are risks around using the criminal law as an education tool. But for the group of perpetrators that you say, despite education, with the full knowledge, they're exploiting a potential loophole because there aren't those laws available to respond to that behaviour. Any new law, now that we have a Human Rights Act, has to go through some level of scrutiny to determine which rights are going to be engaged by that legislation and which are going to be limited. And the discussion paper does, identify some of those rights. I think, when we talk about Aboriginal and Torres Strait Islander communities and also multicultural communities, the cultural rights of those groups really need to be recognised as a potential, I guess, for good in the Balancing Act, but also as a potential harm. So the unintended consequences can cause harm. A question for all of you then, and jump into anybody who wants to go first. The the style of policing that is proposed to change because of coercive control is more one of investigative policing. That's how it's described, that will allow more kind of careful consideration of patterns of behaviour. So violence not just being policed and addressed as a one-off when somebody, you know, might be physically harmed, but coercive control being that psychologically damaging pattern of violence over time. Maybe, look, I'll throw to you, Sam, your thoughts really about any kind of risks to that sort of change in policing style. If we're not getting it right now, what risks do you see?
Sure, and that's a really good question. Thanks, Monica. I think the primary key point to start with here is that on a daily basis, First Nations peoples live with the consequences of Australia's failure to protect their human rights and to continue to experience racial discrimination across all areas, but in particular when they're dealing with the police system as a means of protection. I think if we look at the history of how Aboriginal and Torres Strait Islander people have been treated by police in the past, it doesn't stand to say that this is going to be a more welcoming or more warming process for Aboriginal and Torres Strait Islander families. But in particular, for First Nations women who are expected to walk into a police station, regardless of whether it's an all-women police station or not. I've heard that thrown around as one of an interesting solution for First Nations women. I mean, the fact that they're expected to be able to call police and to say, hey, this is my experience as an Aboriginal woman is ridiculous. I've heard countless stories of women who experience horrendous violence, regardless of whether it's physical or otherwise, who say, there is no chance I am calling the police because they are not going to believe me. Or there is no chance that I'm calling the police because I'm going to end up arrested. And I think that steps that First Nations women take in lots of circumstances and not all to protect themselves are often, again, as I said, misrepresented or misidentified. And as a solution to say, we'll just go more softly for coercive control, I mean, it just doesn't stand to be a solution. If it's not working now, it's not going to work later.
Yeah, thank you. Zoe, I noticed you look like you might have had some thoughts there on that particular issue, or any of the other sort of human rights balancing in that equation, what you see potentially happening.
Look, I mean, yes, there's no question that this particular idea that's been kind of launched out into the Queensland community is one that really challenges our human rights balancing, because on the one hand, I'm sure that everyone listening would like to improve the situation of violence against women, particularly in our most intimate places. When we close that door and we're at home, that's the place where we should feel safe. And we know that it's actually the place where we can feel extremely vulnerable. But any ways that we try to deal with that place at risk other issues. They do place at risk issues around the human rights of those charged with offences, and particularly when misidentification occurs, because we know that there's a greater risk in this area of victims being misidentified, and so it's their human rights. It's their human rights as an offender within the criminal justice system, but they're actually a victim. And that is really complicated. But I just wanted to say about policing. So, I mean, this idea of very careful investigation, obviously there are some benefits in this. And the idea, as I understand it from other jurisdictions, is that it has somewhat changed the way that police have had to think about dealing with domestic violence, because they can't just look at the obvious. Because of notions like a course of conduct offence or a pattern offence, they actually have to start to do things like look at people's phones and actually see how many text messages that they've received. Now, we know that sometimes already happens. Good policing is already doing that, but we also know it doesn't. We also know that it's all very well for some women to feel that they'd be happy to do that, but we know that the history of Australia means that there are many women who are not going to feel comfortable doing that, particularly our First Peoples, but also women from culturally and linguistically diverse backgrounds, and potentially people with disabilities, or there's all kinds of reasons why it might be, if you want to look through the police eyes, you go, oh yes, this could really be a new way of policing. But if you look through other eyes, you can see the difficulties. One thing the last thing I just want to say on this also is that, you know, Australia still suffers from our cultural cringe. You know, we seem to bring over white men from America to teach us about domestic violence. Now, I think there's some very good training being done by white men from America here at the moment, from what I hear, but why did we have to bring a white man from America to tell us about domestic violence? As if there's no woman in Australia who's ever thought about it or ever done anything towards it or ever trained or ever spent like 40 years, perhaps from 1981 when they got admitted as an article clerk, working in the area. But am I invited to go and teach at the family court? No, I'm not. And I get that. You know, we do this thing. And one of the things that we forget when we bring people from America, or when we bring people, specifically in this instance, when we talk about what's happening in England and in Wales and in Scotland, in those places, there is not an Indigenous community that is dealt with in a particular, that history doesn't exist. So when we transplant what is happening in one place and think it can work here, what are we forgetting? The entire, if you read, I'm sure that many people have read some of the social science and other legal literature from England, even their terminology about how they describe people from Asian communities is completely different. We don't, you know, that stuff is not transferable. And I see what happened to the time.
Not a worry, Zoe. We are going to have to wrap it up shortly, but please, before everybody goes, we ask one thing of you, and that is shortly we're going to pop a poll up on the screen for people to just ask a few questions to ask your understanding about coercive control in light of today's discussion. And then there's also some event feedback. So that poll will come up shortly. But look, thank you. I think as speakers today, you've just done such a terrific job of bringing to our attention, obviously, the complexity of designing a new, legislating a new offence of domestic violence. The call out to everybody on the line is to really, whether you think a new offence is needed, and you know, to sort of address some of the issues that Seble so clearly highlighted, or whether you think the risks outweigh the benefits, as we've heard really clearly from Sam, and you know, the analysis that Zoe's given us. We need to express ourselves through the task force process. And the call out really for everybody is to do your homework and actually go and put in a submission, because those experiences in your communities need to be told for the task force to receive that. So look, Seble, I didn't give you a right of reply to anything. So maybe while that poll is going up, you might be able to just say a few closing words.
Yep, thank you. I think it's really good to see it from different angle. I think especially from the human right aspect of it, because the women we are talking about, 1 in 4. So those women who are a victim, this is the law we are talking about to protect. So yes, we again, I really like what Zoe said, just, you know, we need to homegrown. That's what we did in our work, a grassroots understanding, like family peace building, men managing change. We did that to address the issue within in that cultural group to tackle domestic family violence. What we are actually talking is just, we need the legal protection also. There are people who are actually using deliberately to harm the other person, whether Indigenous, cultural, or other groups. But we need, again, we have to know that the problem
So sorry, Seble. It looks like we might have had a bit of internet connectivity issues there. Yeah, okay. And thank you very much for people putting in poll responses. Just to say that QCOS will hopefully take those
Yeah.
views in shaping our own submission. That's all we do have time for today, folks. I want to really thank everybody for staying on the line in the midst of lockdown announcements. It hasn't gone unnoticed at this end here. An absolute, heartfelt thank you to Sam, to Zoe, and to Seble for your time, your wisdom, and your knowledge. Thank you so much. And thank you to the audience for your wonderful participation and your questions. We'll close out the session now. Hopefully there'll be some closing music. Please keep an eye out for QCOS events on socials. We've got another human rights action happening actually this Thursday. So if you want more discussion about human rights, you can find out that by visiting our website. Thank you very much, everybody.